Okay, so all about the EB-2 NIW, National Interest Waiver. This is a really interesting category. This is probably maybe one of my favorite categories. It's one of my favorite. It might be my favorite type of green card because there's so much room to make creative arguments. You can work with so many types of professionals, who are doing really amazing things in their fields. So it's a very versatile type of green card application that can allow for people in a wide range, from the arts to science to law, tons of people we've worked with from many different industries that we've gotten NIWs for. So it allows for a lot of room for me as the attorney to make really creative arguments and work with people to bring out the national interest of what they're doing. So to enter into the EB-2 category, you first need either an advanced degree, so a master's degree, or you need a bachelor's plus 5 years of progressive experience in the field, or you need exceptional ability, which there's a list of criteria for exceptional ability that you meet. If you meet one of those three things, then you're in the EB-2 category generally. From there, you ask, is this an employer-sponsored case through the PERM process, through the labor certification process, or is this a national interest waiver? And so I'm going to focus on the national interest waiver now. Once you're in the EB-2 category, you then ask, is my proposed endeavor in the national interest? So you have to demonstrate that, number one, your proposed endeavor has substantial merit and national importance. Number two, that you're well positioned to advance the proposed endeavor. And then number three, that on balance, it'd be beneficial for the United States to waive the labor certification and thus the job offer as well. What most of these cases fail on is the national importance part of the first criteria. Many things meet that substantial merit criteria, but any sort of general professional pursuit, most of the time, they don't have an issue with the substantial merit part of this. But then when it comes to national importance and what the impact of your work is, that's where these cases break down usually. Most people fail on that. So it's the second part of the first prong is where people have trouble. What this means, national importance, unfortunately, the case matter of Danisar it's a little bit vague. It's hard to really understand exactly what they mean. But through experience, through reading other cases, I have realized that national importance is about the impact that your work has on the field itself, on the country at large, on a state. It could be at the state level. It's about demonstrating the positive impact that you'll have on the field. If you're doing something that is going to further a field more so than someone else who's just a normal employee in the field, and if your work is going to go beyond your specific employer, or if it's going to go beyond your specific clients, that is a national interest waiver. That meets that level of national importance. It's about showing the impact. That's the most important things in these cases. So let's say you've made a good case for the proposed endeavor. You've shown that you're going to impact the field or the country or the state largely, or your area more largely. Then you can move forward to, are you well positioned to advance the proposed endeavor, which is basically, are you able to do what you're going to say that you can do? For example, me as an immigration attorney, I could say my proposed endeavor is to do cancer research, right? That's great. If I'm doing cancer research and I'm adding to the body of knowledge, of the scientific body of knowledge, that's a great proposed endeavor because it has substantial merit and national importance. It would help people not only in the US, but globally, right? Cancer research is a great thing to do. They would say, are you a cancer researcher? They would ask me, am I well positioned to propose the advanced endeavor? I'm just an immigration attorney. I'm not a cancer researcher. So thus, I would fail on that prong, right? So it's got to be something that you're able to do. And a lot of times, if you're talking about doing some sort of entrepreneurial endeavor, being well positioned can mean lining up financing, having a good business plan, like having interested clients or investors or something like that. But if you're in a scientific research position, being well positioned means having a history of this type of successful research, getting grants, having interested governments or third parties or whoever else. So it really changes based on the case. It's hard to say blanket what it would mean for everybody because it's such a diverse category. There's so many different people that would qualify, and in so many different industries that are totally unrelated. For example, I've worked with real estate developers, I've worked with fashion designers, I've worked with people in STEM fields who are working in mechanical engineering and civil engineering, cybersecurity. So there's people in a lot of fields that qualify. You just have to show that national importance and substantial merit. So once you've proven that you are well positioned to advance proposed endeavor, the next question is it beneficial to the United States to waive the labor certification and the job offer? Now, this is a technical legal argument. They're more concerned with, are you going to impact the labor market negatively? And there's a lot of different arguments that we make in this case. For example, to prove this, we talk about the impracticality of a labor certification application. If you are extremely well positioned, if you're really good at what you do, and you would exceed the minimum requirements for a specific job, we can make the argument that, sure, we could find some sort of cancer researcher to fill this position, but this person is extremely good at what they do. They may be bordering on EB-1A, so it doesn't make sense to open the job to the public, because we would certainly find someone that meets the minimum requirements in the U.S. and wouldn't be able to bring this foreign worker to the country. But what they're doing is in the national interest, right? So that's one way that you can prove that they should waive the labor certification in the job offer. Another one is the urgency of something. So if you're working on like a hot button issue that's really debated, that has national security implications or economic security or energy security, anything like that the U.S. is dealing with in the moment, that's if you can prove that you're going to work on this issue and further the interest of the country, and that there's some urgency behind it, that can help you win that third prong also. And lastly, if we can prove that your contributions to the country are important enough that even if another worker is available, we should still bring you to the country, that's the last way that we can prove this third prong and get a waiver of the labor certification in the job offer. And so again, that's pretty subjective. It's hard to nail down exactly what it would be. It's different for every single person. But if you're interested in NIW and you want to learn more about the category or potentially start with the application, feel free to reach out to us. We do these cases all the time. We'd love to talk to you and build a plan for your future.